Hello everyone, you're watching the virtual Amicus and I'm Jay Ludha. Well, today's topic for discussion is on SARFAESI law and its background. The full form is Securitization, Reconstruction of Financial Assets and Enforcement of Security Interests. The Act is of 2002. It's an Indian law that allows and enables banks and other financial institutions to auction residential or commercial properties for the purposes of recovering of loans. Now, this happens when borrowers often and seldom fail to repay back their loans. It enables the banks to reduce their non-performing assets by adopting certain measures for recovery and reconstruction. So, upon loan default, often banks can seize these securities except for agricultural land without the intervention of the court. So, to elaborate further and to give his valuable insights, we have with us a counsel who is known for his clarity of thought, for his precision and his excellent code craft. So we have with us the amicus for today's session, Mr. Anurag Kalavatiya. He joins us on a busy working day. So thank you so much to Mr. Anurag Kalavatiya for sparing time on a busy working day. Now, just to give you all a brief introduction about our speaker today, Mr. Anurag is an alumnus of National Law University, Raipur, which is NLU Raipur, the batch of 2003 to 8. And post his qualification and graduation, he worked with PricewaterhouseCoopers Private Limited, PwC at New Delhi, and he worked there in the direct taxation team for a period of 2 years, where he dealt with various international clients, conglomerates, and after shifting his base to Jaipur, which was in the year 2010, he has worked with a Jaipur-based law firm, which is Chair Amrit Law Partners and Chambers, where he dealt with various practice areas of law, which included arbitration, securitization, company matters, etc. And he also represented various big corporates at Rajasthan. That includes some of the real estate companies, NBFCs, industrial groups, etc. And from the year 2014-16, he was also a counsel for the state government of Rajasthan and for various departments. And at present, he's also a standing counsel for central government for central excise, customs and service tax departments. He has regular appearances before various law courts, forums, authorities such as Honorable High Court, Honorable Supreme Court of India, income tax authorities, appellate tribunals, civil courts, etc. He is also a visiting faculty at the Institute of Company Secretaries of India, Jaipur chapter, and takes lectures on various areas of law. Now, he is currently and at present a managing partner at Amicus Legal, which is a Jaipur-based full-service law firm. And the Amicus Legal is working for many reputed clients and business houses, and is definitely one of the most promising firms that we have in the state of Rajasthan, which has a team of and boasts of a team of 9 lawyers and company secretaries. And their area or core areas of practice include arbitration, direct taxation, indirect taxation, corporate advisory, company law, insolvency, consumer disputes, legal due diligence, land acquisition, civil laws, etc., and etc., to name a few. So thank you so much, Mr. Kalavatiya, once again for taking out time on a working day. So the stage is set. The floor is all yours. Over to you, sir.
Thank you so much, Jay. And I must tell you, the initiative which has been started by you is a wonderful initiative for the people working in the legal field, and the kind of opportunity your forum and you people are providing to the lawyers to discuss on various practice areas of law is simply superb. And not only the lawyers but the general public who will hear these lectures can get to learn a lot about the various practice areas of law. So thank you so much for inviting me here for deliberating on today's topic, which is the SARFAESI law and its background. So to start with, if we start with the SARFAESI law, as Jay has already discussed the full form of the SARFAESI Act, which is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. So as you can see, this act was incorporated and implemented in the year 2002 in India. So why it is important to discuss its background? Why in 2002 we can see that the Indian banking industry is more than 200 years old at present. If we dig deeper into the background of the banks in India, in fact, the first bank which was opened in India was way back in the year 1770, which was the Bank of Hindustan. And thereafter, the State Bank of India, which is today known as State Bank of India, was originally opened in the year 1809 or 1807 somewhere, and gradually it went through various phases and then finally came in as the State Bank of India. So if we see the background of Indian banks, there is a history of more than 200 years old history is available with us. But why this SARFAESI law has come up only in 2002? What is its background? So therefore, the background is very important to be discussed. So before this law of SARFAESI Act 2002, the previous act which provided any sort of special forum to the banks to approach and get their NPA account settled, or to get their remedy in respect of non-payment of their loan amounts by the borrowers. The previous act in this regard was the RDDB and FI Act 1993. The full form of that is Reconstruction of Debts Due to Banks and Financial Institutions Act 1993. So that act was formulated or incorporated in India for the first time in the year 1993 to provide some kind of mechanism specifically for the banks, where the banks can approach and seek remedy in respect of non-payment of their huge NPA accounts. So if we see in today's perspective also, the banking industry always suffers from a very big problem, that is accounts, the borrower's account becoming NPA, that is non-performing asset. What that means is, when any borrower takes a loan from the bank and after some time stops paying installments and stops paying that loan amount, that loan account has to be declared by the bank as per the various notifications and the guidelines issued by the Reserve Bank of India. That loan account after a certain point of time can be declared as a non-performing asset for the bank, and the bank declares that account as NPA. Thereafter the bank can initiate various recovery proceedings against that borrower. So before 2002, the first act in this regard was of 1993, that is Reconstruction of Debts Due to Banks and Financial Institutions Act of 1993. So what does that mean? Before 1993, which we can see that before 1993, there was no law at all, specific law at all for the banks, where the banks could approach and seek their remedies in this regard. So if we talk about the scenario prior to 1993, I can tell you that at that point of time, before the 1993 Act of 1993, every bank used to approach the civil courts for by filing a suit for recovery of their own money. So you can see the plight of the banks at that point of time till the year 2002. A bank gives a loan to a borrower approaches the bank that I need a loan of 10 lakh rupees. The bank says yes, you can take, and the bank takes some mortgage property, some security in the form of some property. That person, after taking loan from the bank, stops paying that loan account after some point of time, and still the bank has to run for its own money. So that was a very such a bad situation for the banks in the country, where there were huge accounts were getting NPA, and despite that the bank used to approach the court of law, file the suit for recovery, pay the court fees also in this regard, and then fight for years altogether to get their own money back. So various committees were formed, fruitful result could come out. But thereafter in 1993, for the first time, this Act of 1993 was implemented. But that also could not provide much the relief which was being sought by the banks. That 1993 Act, what that Act did was only created a specific forum for the banks to go. That instead of now going to the civil courts, by the Act of 1993, a specific forum called as Debt Recovery Tribunal was created, and which provided that in case any bank's loan account becomes NPA, instead of approaching the civil court, the bank can specifically and easily approach Debt Recovery Tribunal by filing an original application and seek remedy of attachment of property from the by the order of the court, and also the court fees which was being charged on such recovery matters was also reduced to some extent by the Act of 1993. But yes, that all Act of 1993 also could not provide the relief which was being sought by the banks. So thereafter, again, in the year 1995, the central government appointed a committee for looking for better prospects, better law in this regard. And thereafter, in the year 2002, finally, the central government came out with this new act, that is the SARFAESI Act 2002. Now, what does that mean? If the SARFAESI Act has come into force in the year 2002, has the previous law of 1993 been abolished? Has it been repealed? So the answer is no. The RDTB Act of 1993 is still very much in existence and can be used still by the banks as an additional remedy along with the SARFAESI Act of 2002. Now, what does this? We have already discussed about the background. Now we will briefly discuss about the main provisions of the SARFAESI Act as to how this act, has given much respite to the banks. So I will, for that matter, I will just share my PPT with all of you. So as you can see my PPT. Now, history we have already discussed. Now, this act of SARFAESI was implemented with effect from 21st of June 2002, and this act majorly provided that now after coming into force of this act, the bank had to go nowhere. Now the onus to approach the courts was put upon the borrower instead of the bank. So this act gave the banks a much needed relief that in case a borrower makes a default in payment of its loan accounts, the bank has to go nowhere. The bank can directly initiate recovery proceedings on its own against the borrower by first issuing a demand notice in this regard, and thereafter, even after 60 days of that demand notice, the borrower doesn't pay the amount of loan, the bank can straight away go for taking possession of the property and thereafter selling it in the open market by way of open auction or by way of a private treaty or by handing it over to a asset reconstruction company. So now the banks were given the relief that now once a borrower makes a default, you can directly take action under the provisions of SARFAESI Act, and it is the borrower now who will have to approach the courts, that is the debt recovery tribunal. So as far as the jurisdiction in respect of SARFAESI Act is concerned, that is also available with the debt recovery tribunal. But here in the new act, instead of bank going to the court, now the borrower has to go to the court and pay a court fees for getting its matter heard and then seek whatever relief is possible. But the relief also which was available to the borrower was also reduced or curtailed to a great extent in the new act of 2002. Now we'll go with the major provisions of this act. So this act is majorly covered in 42 sections. It's a very small act, 42 sections and divided into 6 chapters. But as far as the practice area is concerned, the first 3 chapters of this act are important for us to go through and which are majorly used in practice in the courts, in the debt recovery tribunal. So the chapter 1 talks about the its applicability to the whole of India, including the state of Jammu and Kashmir. Though this act was implemented in the year 2002, but still from the day one, it was applicable to whole of India, including J&K. This is very important to note. Why? Because the banks in India were already operating in the state of Jammu and Kashmir also. So they cannot be, it cannot be the fact that a State Bank of India branch in Rajasthan is governed by the SARFAESI Act and in the State Bank branch in Jammu or maybe Kashmir is governed by say some other act. So since it was relating to the banks which were having branches all over the country, so that is why despite in all other acts we would see that the jurisdiction over state of Jammu and Kashmir is always excluded. But this act from the day one had jurisdiction over the state of Jammu and Kashmir as well. So certain important concepts are there in this act, which you can note down, like, it defines the term borrower. Who is the borrower? Now we all know the definition of term borrower, who takes money from the bank, right? But it includes a guarantor also. So this act provided relief to the bank that if the borrower becomes bankrupt or the borrower refuses to pay or the borrower, just vanishes, you can take action against the guarantor of that loan in equal measure. So the guarantor steps into the shoes of the borrower as per this act as soon as the borrower refuses or the borrower is unable to pay. Now the small other definitions are there, like default. What is default? Non-payment of any debt which is payable by the borrower to a secured creditor. Now there are some other assets, like the very important definition is of non-performing asset, which I have already discussed. The loan account becoming NPA. So what is the definition? It says asset or account of a borrower classified by bank or financial institution as substandard, doubtful, or loss asset in accordance with the asset classification guidelines. So these asset classification guidelines are issued from time to time and improved time to time by the Reserve Bank of India. And as per these these guidelines, the banks can classify any account as NPA. The general, or the general practice which is followed by all the banks is that if a loan account, if a term loan has been taken by a borrower and he doesn't pay 3 consecutive installments for 3 consecutive months of that loan account, then in the fourth month, immediately upon 90th day, the bank can declare that account as NPA. And nowadays, this is not a manual process that the authorities of the bank would do it. The system in the banks, which is which handles the entire mechanism. So the automatic system is there, which declares that account as NPA immediately only on the 90th day, when the account when there is no repayment in the last 3 months of the loan installments. This is with regard to the term loans. But what is with regard to the cash credit accounts? Cash credit is CC limits, where the bank gives various cash credit limits to the businessmen for running their day-to-day affairs of business. So in those cases, since the entire money is deposited in the CC account only by the borrower, so if the borrower is regularly running that account, well and good. If the borrower doesn't running any business through that account for a period of 90 days or more, then in that case, that account can also be declared as NPA. So it is as far as the cash credit accounts is concerned, it is not only with regard to the repayment of interest or repayment of principal or repayment of principal and interest on the loan account. It is also with regard to the So apart from the definition of non-performing asset that we have discussed, that is the asset or account of a borrower classified by bank or financial institution as substandard, doubtful, or loss asset in accordance with the asset classification guidelines. So this is a very important definition in the SARFAESI Act, which according to which the banks and financial institutions can declare a loan account of a borrower as NPA. So in this regard, the detailed guidelines are being issued from time to time by the Reserve Bank of India, and they are being amended from time to time. Now thereafter, there are certain other important definitions, like the definition of secured asset. Now what is a secured asset? On which the bank has the right to take possession and sell it off. So that is a property on which security interest is created. Now there's a definite secured creditor. Who is a secured creditor? So therefore the definition says any banks, financial institutions, debenture trustees, asset reconstruction companies, or any other trustee in whose favor security interest is created by a borrower is a secured creditor. So all these people who are whose names are there in this definition can approach, they can take actions under the SARFAESI Act 2002. However, I mean, every financial institution, every debenture trustee cannot approach or cannot take action under the SARFAESI Act. Their names are, from time to time, the RBI declares a list of financial institutions or amends or, keeps improving the list of financial institutions and debenture trustees and banks who can take action in accordance with the SARFAESI Act 2002. Now, the chapter 2 of this Act of 2002, we have already discussed chapter 1, which primarily deals with the definitions. So chapter 2 primarily deals with the regulation of securitization and reconstruction of financial assets of banks and financial institutions. So what this chapter 2 primarily deals with is the role of asset reconstruction companies with regard to the banks and their NPA accounts are concerned. So this chapter 2 primarily tells us that in what manner a bank can sell its own NPA account to a asset reconstruction company, and thereafter how will that asset reconstruction company will take care of that NPA account. Will it they can sell it off, or they can manage that particular NPA account, or they can formulate a scheme for revival of that NPA account. So all those things are primarily governed under chapter 2, which is deals with the registration of ARCs with RBI and the further modes in which the ARCs, that is asset reconstruction companies, can take care of a NPA account. We are not going in detail as far as all these procedures are concerned, because that will take a longer session for us to delve upon all these points. We can have a longer session there at some point of time if we take section by section. But as of now, in the present discussion, we are only having the overview of the entire act and the background. So now the chapter 3 is a very important chapter for us, which is primarily used by lawyers for contesting litigation before the debt recovery tribunal. Now this chapter 3 deals with enforcement of security interests, and this is where the banks can take action against an NPA account under chapter 3. Now in this, the very important section is section 13. So section 13 gives the power to the bank to take possession of a property, of a secured asset of a borrower, if the borrower fails to pay the amount of loan, and once the bank declares that account as NPA. So this section 13, what does it say? Is section 13 is a very lengthy section running into 13 clauses, 13 sub clauses. Under section 13, the first and foremost very important clause is section 2, subclause 2, which says that if the account has been declared as NPA by a bank, as we have already discussed, if there is no repayment of loan installments for a continuous period of 90 days, that is 3 months, by a borrower, the bank can declare its account as NPA. And that NPA gets done automatically nowadays by the bank system. There is no manual entry by the bank for declaring an account as NPA. So once that account is declared NPA, what the bank does is, under section 13 clause 2, it sends a demand notice to the borrower. And what that demand notice states primarily is, that is that's a kind of a format wherein the bank mentions each and every loan account, what was its initial limit for the initial sanctioned amount of loan, what is the outstanding of that loan as of now, and then the bank mentions the date of NPA in that notice, that on so and so date your account has been declared as NPA by the bank on account of non-payment of the amount. And therefore, in the last para of that notice, the bank demands that the entire amount of the loan accounts has to be paid by the borrower within 60 days of receipt of this notice. So section 13(2) demand notice provides the borrower a time limit of 60 days after receipt of that notice to either pay the entire borrowed amount back to the bank, or enter into any kind of negotiations with the bank, that if in some circumstances the bank may agree to the fact that instead of repaying the entire amount, so for example, like a person took a loan of 1 crore rupees from a bank, and he has paid, maybe you can say 25 installments he paid of 1 lakh rupees each, and now the 75 lakh rupees are outstanding, and he thereafter fails to pay that amount for a continuous period of 3 months. So the bank will declare his account as NPA after the 3rd month. So as on date, when the demand notice gets issued, there may be an outstanding along with interest of some 77 lakh rupees, or maybe much more as per the interest calculation. So that will be the outstanding amount. So in 13(2) notice, the bank will direct the borrower to pay the entire 76 lakh rupees. It's not that the bank will say that you pay only the 3 installments which have not been paid. That's not the case. The bank will say that since we have declared your account as NPA, so therefore now you pay the entire 76 lakh rupees or 77 or whatever the amount is in one go. So at that point of time, what the borrower can do, if the borrower approaches the bank after receiving of 13.2, there is a further section 13.3a, in which the borrower has the right to submit its grievances and objections before the bank in respect of declaring his account as NPA. So any kind of objections or submissions or any requests can be made by the borrower by making an application or an objection application under section 13.3a, or maybe by way of directly going to the bank authorities and talking to them in this regard. So at that point of time, what the bank, if the bank agrees to the fact, the bank, what the bank can do is just accept the 3 installments and regularize the rest of the further installments. But that case normally doesn't happen with the banks. These days, the banks are very strict with their 13.2 notices. So the banks normally does not, accept such requests of the borrowers. So the bank recalls the entire amount of loan which is outstanding as on that date. Afterwards, if you give 13.3 objections to the bank has the responsibility or duty to decide those objections by way of a written reply in this regard. If the bank doesn't decide that those objections by way of a written reply within 15 days of receipt, the 13.2 notice can be challenged thereafter even before the High Court, or in some cases before the High Court or before the DRT. I will explain how you can come directly before the High Court also, challenging a 13.2 notice. So 13.3a objections have to be dealt with specifically by the bank, and they have to be replied in by way of a written order in this regard, or a written reply in this regard. Now, once the 60 days are over and the borrower still doesn't pay the amount, and there is no kind of mutual settlement between the bank and the borrower, now what? Now thereafter, after lapse of 60 days, which are mentioned in the 13.2 notice, the bank can directly go ahead by taking action under section 13.4. So that is very important for the banks. Under 13.4, what the bank does is, the bank takes a symbolic possession of the property of the borrower by pasting a notice outside the main wall of the property. So if there is a house, or if there is a factory, or if there is any other property which is situated at some place, what the bank will do, the bank will issue a notice also in this regard, section 13.4 notice of, we call it in general parlance, symbolic possession notice. So symbolic possession notice will be sent to the borrower by saying that within the last 60 days which we had given you, you have not paid the amount. So therefore, we are declaring your account as NPA. We have already declared account as NPA, and now we are taking possession of your property. After sending that notice, what the bank will do, they will also paste that notice outside the wall or at any conspicuous place, maybe at the main gate of that property, so that any person thereafter, if any person enters into any transaction with that borrower, maybe what the borrower may do is, even after his accounts gets NPA, becomes NPA, the borrower may try to sell off his property to someone else. So in order to avoid this thing, the banks, what they normally do is, they send a notice first, they paste the notice outside that property, and they also give a public notice in the newspapers in this regard, that we have already declared this account as NPA and he has not paid. So we have taken symbolic possession of your property, and we have declared your account as NPA, and now we are taking possession of your property. So this is how the bank normally challenge a 13.2 notice. So what is the remedy? So what is the remedy after a person receives section 13.4 notice? Now, after receiving 13.4 notice, the borrower can approach the debt recovery tribunal by filing a securitization application under section 17 of the SARFAESI Act 2002. So here only I would explain how you can go directly to the High Court in some circumstances. The section 17 of the SARFAESI Act, which provides the right to the borrower to approach DRT. The section 17 says that a borrower can only approach DRT after receiving section 13.4 notice and not before. So in a case where you receive a section 13.2 notice, which is itself illegal, which is itself without authority of law, or maybe which is itself you were regularly paying and the bank has incorrectly or wrongly declared our account as NPA. So at this stage of 13.2, you cannot go to DRT in terms of SARFAESI Act. So in those conditions, you can directly approach the High Court by mentioning that at this stage I cannot approach DRT. So therefore, I am excising. I'm coming before this honorable court under Article 226. So in those conditions only, you can directly go before the High Court. Otherwise, the Supreme Court has, in the last couple of years, has come down heavily upon various High Courts where they have interfered in the SARFAESI proceedings by saying that since there is a specific tribunal for that purpose, the borrower may approach the DRT instead of approaching High Court. So these days the High Courts are very much reluctant in interfering in any Section 13(4) proceedings instituted by a bank, even if they are per se arbitrary or per se illegal. So Section 30, after Section 13(4) notice is issued of symbolic possession, what the bank will do thereafter is the bank will take steps to take physical possession of your property. One is symbolic possession of Section 13(4). Thereafter comes is physical possession of your property. And for that, what the bank will do, if the bank thinks that there will be some kind of a problem or some kind of resistance from the borrower in taking a physical possession of his property. So, if you take an example, if there's a property which is totally vacant, the borrower is also not very much concerned about the property, and the bank thinks that the possession of the property can be directly taken without any much resistance from the borrower side. The bank will paste the notice in the Section 13(4), and the bank will directly put its board outside the property by mentioning that it's now in terms of the proceedings initiated under SARFAESI Act, this property belongs to the bank. But in case there is a house property, there is a running factory, where the bank thinks that the borrower will show some resistance in giving, physical possession of his property, of his secured asset, then in such cases, the bank goes before the court of, CJM, that is Chief Judicial Magistrate, or before the district collector under Section 14 of the SARFAESI Act and files an application therein. That action under Section 14 is purely an administrative action. It is not a judicial action by the CJM or by the court of judicial magistrate, by the court of district magistrate. And under Section 14, the concerned court of district magistrate or the chief judicial magistrate will take steps to provide physical possession of the property of the secured asset to the bank. In that case, the concerned court passes an order and directs the police authorities to go along with the bank officials and take proper physical possession of that property. So when the authorities, after taking order under Section 14, goes to the property, they take steps, in the manner that they draw out a proper panchnama as to what are the properties which were available, which were there apart from the land and building. So they take each and every property or the movable or immovable properties lying in that property. They draw a detailed panchnama of those properties, and then they get it signed from the borrower, and then they take physical possession of that property. And in such cases, if only the, in some cases, if the house property is mortgaged with the bank, so in some cases, the bank takes possession of the property on as is where is basis, that whatever is there in the property, they will take entire possession. But in some cases, if the vacant possession of the house is to be taken, if such a clause is mentioned in the, the mortgage deed, that the house has been given as a mortgage, as a vacant house, then the borrower has the right to take away all those belongings which are not mentioned in the mortgage letter. So in that case, the bank provides option to the borrower that you may take away all the belongings, all the movable properties apart from this house, you can take away from the property, and then we will take a possession. So in such circumstances, the bank takes the possession under Section 13(4) along with Section 14. Now thereafter, what the bank does is the bank takes steps as per Section 13(8) to sell off the property in the open market by way of open auction. So under Section 13(8) of the SARFAESI Act, the bank issues advertisement in the newspapers regarding open auction of the property, public auction of the property, and in that public auction, any third party can participate and can purchase the auction property, the secured asset of the borrower. Now, at this stage, also a right is given to the borrower. We have already seen first right is given to the borrower under section 13(2) when the demand notice is issued. At that time, within 60 days, the borrower can pay the entire amount and can restore his account, or he can take back his all secured assets. But even thereafter, when the bank issues a public notice regarding auctioning of the property, till the auction notice is issued by the bank in the newspapers, public notice is issued. Till that stage, also the section 13(8) provides a provision to the borrower to claim that property even till that stage by making entire payment of the outstanding amount to the bank. But once an open auction advertisement is issued and the open auction takes place and a person makes a bid for that property and the bid becomes successful, after that, the right of the borrower to redeem his property expires or extinguishes. So a borrower has the right to redeem his property from the bank till the stage when the public notice is issued but not finalized. So till that stage, the borrower can approach the debt recovery tribunal by filing a securitization application under section 17 and can request or can pray before the debt recovery tribunal to direct the bank to give his property back to him. Apart from that, under section 17, certain other remedies are also available to the borrower in case proceedings under section 13(2) and 13(4) are issued by are taken by the bank. So some of those reliefs which can be sought by a borrower from the DRT are that in some cases the loan account has entirely wrongly been declared as NPA. In some cases where the interest has been wrongly charged on the loan accounts. In some cases where the bank authorities have in order to sell off the property to its own persons, they are issuing the public notice of auction in a wrong manner, or they are not issuing the public notice in some newspapers of repute. So there are rules in this regard. There are security interest rules of 2002, wherein section 8 rule 8 and rule 9 discusses in detail about the process in which the bank can auction a property and can receive its own outstanding amounts. If the bank doesn't follow any of such things which are specifically mentioned in the rules, the borrower can definitely approach DRT under section 17 and can seek relief. Now here, if a borrower is unable to get any relief from DRT, there is an appellate remedy also available, which is DRAT, wherein under section 19 of the Act, of the SARFAESI Act, the borrower can approach DRAT also, that is Debt Recovery Appellate Tribunal, against any decision of the DRT. Similarly, if the bank is aggrieved against any decision of the DRT, the bank may also approach DRAT under section 19. But in case of borrower, the provision of appeal is slightly, very hard for the borrower, because in such cases, if the borrower aggrieved against the order of DRT approaches DRAT in appeal, then there is a pre-deposit of minimum 50% amount of the total outstanding. So for example, if there is a outstanding of 1 crore rupees and your account is declared NPA, and thereafter you approach DRT and DRT dismisses your application, and if you want to go in appeal, 50 lakh rupees, that is 50% of that 1 crore rupees, has to be deposited before the DRT in the form of pre-deposit, and then only your appeal can be heard. Now, this provision was challenged earlier in the case of Murdia Chemicals before the Honorable Supreme Court, and wherein the Honorable Supreme Court, by way of, though upheld the constitutional validity of this provision, but directed the authorities to lower down this limit of 50% to a certain lesser amount, whereafter amendment was brought into the this provision, and now the first provision is that the person has to deposit 50%, but If the person is unable to deposit 50%, he may file an application before the DRAT to reduce the amount to 25%. But below 25%, no authority, DRAT or even the Supreme Court cannot reduce the amount before 25, below 25%. So minimum pre-deposit amount is 25% in the appellate remedy, that is section 19 of the SARFAESI Act. Now, one last and very important thing in this law to discuss is which properties are not governed. We have to also see which properties or on which assets the bank cannot take action as per the SARFAESI Act. So for that, the section 31 of the SARFAESI Act provides which all properties or which all assets are not covered under the SARFAESI Act. It says provisions of this act not to apply in certain cases. So one of the very important properties on which SARFAESI Act doesn't apply is agricultural land. So we have to keep this in mind, that if any of our client comes with a matter wherein the agricultural property was mortgaged and the bank accepted the mortgage property, the agricultural property, and thereafter take action again under SARFAESI, we can definitely get that matter quashed from the DRT or maybe from the appellate courts, since the agricultural properties are not governed under by the provisions of SARFAESI Act. Similarly, like there are some other properties like lien on any goods, money or security given by or under the Indian Contract Act or the Sale of Goods Act or any other law for the time being in force, pledge of movables within the meaning of section 172 of the Indian Contract Act, creation of any security in any aircraft, creation of any security in any vessel. So these are not very much, as far as the aircrafts and vessels are concerned, those may not be very much useful for us practicing here in Jaipur. But yes, as far as agricultural land is concerned, you may be seeing various cases. I mean, where the banks or maybe financial institutions have wrongly taken the agricultural land as secured asset, and in those cases, the bank does not have authority to initiate proceedings under the SARFAESI Act. So this is basically a brief background about the SARFAESI Act, and all these things we have already discussed. So by incorporation of the SARFAESI Act, the Indian banks have the power of the Indian banks to recover their loan accounts has strengthened. Earlier there were no such provisions available. So the provisions have certainly given the banks a strengthening position. They can recover their NPA accounts in a much better capacity now, since they can auction the properties. And that's it from my side. And so this was a brief background about the entire act. If any specific provisions have to be dealt with in future, we can take further, we can further deliberate or delve upon all these issues. So thank you so much, Jay, for giving me this time and opportunity to interact with everyone.
Thank you so much, Mr. Anurag Kalavatiya, for joining us and sparing out time from your busy schedule on a working day. And thank you so much for those valuable insights on a topic that needed and demanded an expert from that very field. So I am sure that this presentation of yours will immensely benefit all our viewers. And still, if any of you have any queries on any of the concepts or fundamentals with respect to the SARFAESI law or its background or its practice, then feel free to write to us. We'll be more than happy to forward the same to our keynote speaker, to our amicus for today's session, Mr. Anurag Kalavatiya. And you can write to him directly as well. So thank you so much, Mr. Anurag Kalavatiya. Once again, thank you all for your patient viewing, and stay tuned. Next episode is on its way. Please like, subscribe, and share my channel. Stay home, stay indoors, stay safe. Please take good care of yourselves. Venture out only when it's very important. So thank you all. That would be enough. Thank you.
Thank you.